Now, as we await the arrival of those 700 Marines, California's top leaders are going to court to block what they call Trump's unlawful militarization of Los Angeles. A hearing is actually set for this afternoon on California's emergency request to block the administration from expanding the mission of the Marines and California's National Guard. DOJ lawyers calling the lawsuit a crass political stunt. My next guest will be in that courtroom arguing for the state of California. Joining me now, California Attorney General Rob Bonta. Rob, good to see you again. The last time we talked was during the wildfires. Now you are dealing with this. You are getting ready to go to court this afternoon. Give me a preview. What will you argue? How will you argue?
Well, great to see you again, and thank you for having me. We have a hearing afternoon at 1:30 p.m. in San Francisco in the federal courthouse, and we'll be making the case we've been making since day one, since we filed our complaint on Monday and our temporary restraining order request on Tuesday. We argue that the president is engaged in an unlawful power grab, that he's trying to exercise authority that he doesn't have, that the commander-in-chief for the National Guard, the California National Guard, under these circumstances is Gavin Newsom. And there was no authority or statute that triggers the president to deploy the National Guard to Los Angeles. So we argue that his deployment of the National Guard to LA is unlawful and thus invalid. We also argue that the Marines, of course, as a military entity, are subject to the Posse Comitatus Act and cannot engage as a military entity in civilian law enforcement and must be restricted so that they're not involved in civilian law enforcement. So we think we have the better of the facts and the law. We've seen the opposition filed by the federal government, and we think we'll prevail today.
What happens if the court doesn't agree with you today, Rob?
Our case continues. Today's a request for a temporary restraining order. So all the arguments in our complaint continue. We might be able to seek a preliminary injunction or seek an order at the end of the litigation. So today is one step along the way, but we do believe, as we have in a supermajority of the 25 cases that we've brought against the Trump administration, we believe we'll prevail and secure the order that we're seeking.
Bear with me for a minute, Rob. I want to give a little historical perspective here. The other time, last time in history, that the president deployed the National Guard against the wishes of the governor of a state was 1965. President Johnson deployed the National Guard as well as active duty military to Alabama to enforce desegregation, citing the, quote, likelihood of domestic violence and obstruction of the execution and enforcement of federal laws, end quote. President Trump says that these protesters are obstructing federal law enforcement and committing violence. Does precedent exist here, even though they are very different situations?
There's no precedent for what the Trump administration is trying to do here. The example that you cite is based on a different law entirely, and the concern was about the deprivation of rights to those who were peacefully protesting and the civil rights not being enforced, that they had protections for and that attached to them. Here, the citation that the president refers to is 10 U.S.C. 12406 to authorize purportedly his deployment of the National Guard to Los Angeles. And it requires one of three things: an invasion. There is absolutely no invasion. No one can credibly say that. A rebellion? There's no rebellion either. No one can credibly say that. Or the inability of the federal government to execute the laws of the United States. That doesn't exist either. And even if you have one of those elements which do not exist, you also have to have the cooperation or consent of the governor of the state, Governor Gavin Newsom. He has strenuously objected to the National Guard coming in. So if you just look at the plain, unambiguous language in black and white in the citation in the law that is cited to by the president, they fail, and they do not have the authority to call in the National Guard. The one time this statute in the history of the United States was used to call in the National Guard was during the United States Post Office strike, when the constitutional requirement and federal statutes requiring mail to be moved to the U.S. Postal Service when they weren't able to be executed. So the National Guard came in and moved the mail. Very different circumstances than here. And by the way, the local law enforcement, the LA Sheriff's Department, largest sheriff's department in the nation, the LAPD, third largest police department in the nation, are very well resourced, highly trained, have men and women that do exactly this. They tackle crime, they confront crime, they quell situations, and they've done it well here. And they have a whole set of mutual aid that they can request if needed. And then at the end of that, they can ask for the National Guard from the governor if they need that. But you heard the police chief of LA last night saying they're nowhere near needing to call in the National Guard and haven't even come close to depleting the mutual aid resources. So things are well in hand on the ground. Of course, there are challenges, and that's what law enforcement agencies do. They tackle the challenges when they arise.
Attorney General, appreciate your time today, and we'll continue to follow what happens in court. I hope you'll come back and speak to me after you make arguments.
Happy to. Great to see you again.
Thanks, Rob.